Hello friends, in the series on income tax cases today we will discuss a very important case on section 142A which talks about reference to the DVO by the assessing officer for the valuation of the investment. The issue before Honorable Telangana High Court was that if the assessing officer is not satisfied with the amount of the construction projects which the assessee has shown into its balance sheet, and the assessing officer without finding any defects in the books of accounts or without rejecting the books of accounts as per the mandate of section 145 subsection 3 refers the matter to the DVO, and on the basis of the DVO makes the addition under section 69 for unexplained investment. So whether in that case that addition under section 69 is justified without rejecting the books of accounts as per the mandate of section 145 subsection 3. This issue has been decided by Honorable Telangana High Court in the case of Commissioner of Income Tax versus Regent Estate Private Limited, and this case is reported in 186 taxman.com 1170, and the date of the judgment is 26th March 2026. The present case relates to the assessment year 78. The assessment proceedings of the assessee were going on. The assessee, some projects relating to the construction were in the pipeline. The assessing officer was of the considered view that the assessee has made more investment in those projects that have been shown into the balance sheet. So he referred the matter to the Department Valuation Officer as per section 142A, and when the report of the DVO came to the assessing officer, then the assessing officer, on the basis of the department valuation report, calculated a figure which was more than the figure of construction project shown in the balance sheet, and the assessing officer made the addition of the difference amount under section 69 as unexplained investments by taking a view that this much of the amount has been invested out of the books or by assessee by the sources which are not explained. When the matter was before the Honorable Telangana High Court, the assessee took a very pointed issue that in the present case the assessing officer has not found any defect in the books of accounts. The assessing officer has not rejected the books of accounts as per section 145 subsection 3. So the assessing officer has not mandated the substantive provisions of referring the matter to the DVO. The matter to the DVO can be referred only under section 142A, section 142A only in case when the assessing officer has rejected the books of accounts as per mandate of section 145 subsection 3. Since the books of accounts has not been rejected, so the reference to the DVO as per 142A is not valid. The court said that in the present case, the AO cannot solely rely on the department valuation report to make additions by invoking section 69 and by invoking section 142A. Friends, this case is very important because when the assessing officer is not satisfied with the amount of the investments or with the amount of the construction projects in the balance sheet, so the assessing officer cannot make the reference to the DVO on his own whims and wishes. It is the task of the assessing officer that he has to make an opinion by finding the facts that why he has formed that opinion and why the books of accounts cannot be relied, and he should point out the defects in the books of accounts, and accordingly by giving a reasoned order reject the books of accounts of the assessee by giving a proper opportunity to him, and only then he can refer the matter to the DVO. And even after coming the report of the DVO, the assessing officer has to confront that report to the assessee before accepting that department valuation report. So in the present case, the addition under section 69 for the unexplained investments was deleted by the Honorable Court by saying that the reference to section 142A to the DVO has been made without rejecting the books of accounts under section 145 subsection 3, which is not as per law. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax 4 versus Legend Estates Private Limited, and this case is reported in 186taxman.com 1170 Telangana High Court, and the date of the judgment is 26th March 2026. Thank you, friends.